press are not allowed, no access to it. They hear it at trial. So defense would argue that defense meets the three prongs by the preponderance of the evidence, which is the standard that defense had to meet the prongs by as to each of the factors, and the court should grant defense's motion to close the pretrial proceedings.
Thank you, Mr. Smith. State.
Judge, it's the state's position that they haven't shown anything by a preponderance of the evidence. There is massive worldwide coverage of news these days, but it's very spread out and only deep in very certain puddles. A basement in Sheffield, England may have hit the Reddit, may have hit the YouTube, may have hit all those different sources of news, but they have not shown any nexus to the potential jurors in Osceola County, Florida, and all of the data that they presented to the court. They didn't even show you how many views any of those YouTube videos got, how many upvotes or downvotes any of those Reddit posts got. They haven't shown you how many people viewed any of those news stories, much less how many people in Osceola County jury, Osceola County, Florida, they're eligible to serve in the jury, viewed any of those things. There hasn't been a study conducted by a UCF student, for example, to go out and poll jurors and provide the court with data about the effectiveness of the media coverage in this case in conveying its message. The unfortunate truth that I have found, because as this court knows, I ask every potential jury panel, do you even follow the news? Do you get a newspaper? Do you watch the local news? And it's stunningly small how many people actually follow the news. And in a high profile case that I just did in October up in Orlando, had a whole subreddit and all the YouTube and the sleuths and all the stuff that they presented you. We put 50 jury panels Monday morning, 50 jury on the panel Monday afternoon, Tuesday morning, Tuesday afternoon, and maybe 2, 3, or 5 in each panel of 50 had even heard of the case. And perhaps 2 got excused for cause because of their exposure to the case. I don't say that as evidence. I say that as an anecdotal link to, well, where's the link to Osceola County? The YouTube is not just exclusive to Osceola County. WESH isn't exclusive to Osceola County. Reddit certainly is not exclusive to Osceola County. Where's the data about the effectiveness of the message in Osceola County? And it's just not there. And I would submit that without it being there, there's no data for the court to decide that there's a preponderance of evidence shown that this media has been effective in convincing anybody in this county about anything.
Thank you, State. Mr. Minchin, I'm going to invite you to the podium. Mr. Minchin, I've reviewed Miami Herald. I'm not convinced that there's an automatic entitlement to intervention. I think that's still requires leave of court, but I do want to give you an opportunity to proffer the argument that you are intending to make. I will, in a written order, indicate whether the court considered that argument in making its final determination, and I'm going to give the defense an opportunity to respond to both the state and any argument made.
Thank you, Your Honor.
Whenever you're ready.
I was able to locate some authority for that proposition. However, even within the Lewis case itself, if you look on page number 7, that's head note 6, and then some other case law as well. Quote, the news media has been the public surrogate on the issue of courtroom closure. Therefore, the news media, quote, must be given an opportunity to be heard on the question of closure prior to the court's decision. Also, Chavez versus State says the same thing. Notice and opportunity to be heard prior to closure. Pinnock versus State also, notice and opportunity to be heard. Those are second DCA cases as well. So that is the authority that I'm moving under the Supreme Court's decision that notice and opportunity must be given.
Thank you. When you're ready, argument.
Yes, sir. From the onset, I just wanted to point out that this is, in fact, an evidentiary hearing, and the only evidence that has really been proffered to this point has been that there has been a lot of media coverage of these proceedings, and that's typically the way it works in these cases. Typically, there has been a lot of media coverage, but that has never been sufficient to justify closure. Lewis says, quote, those seeking closure must carry their burden to demonstrate a strict and inescapable necessity of closure, strict and inescapable necessity. And that is an extremely high standard, and that's that phrase, strict and inescapable necessity of closure, that has been used in the case law since then. It is an exceptionally high standard because there is a strong public policy in favor of openness and transparency in the proceedings. Some of those reasons are that it enhances legitimacy, credibility, public trust in the judiciary, protecting the accused rights, keeping judges, prosecutors, and witnesses honest. There's a lengthy quote, I'll summarize it from the Lewis case from the Supreme Court that says, public access to courts, this is quoting, is an important part of the criminal justice system as it promotes the free discussion of governmental affairs by imparting a more complete understanding to the public of the judicial system. Such access gives the assurance that the proceedings were conducted fairly to all concerned. And aside from any beneficial consequences which flow from having open courts, the people have a right to know what is going on. As the Supreme Court has noted repeatedly, the trial is a public event and what transpires in the courtroom is public property. Public access also serves as a check on corrupt practices by exposing the judicial process to public scrutiny and protects the rights of the accused pursuant to a fair trial. Finally, because participating lawyers, witnesses, and judges know that their conduct will be subject to public scrutiny, it is fair to conclude that they'll be more conscientious in the performance of their roles, summarizing most of the public policy arguments that we have on that. So the Lewis, you know the three factors, elements rather, they're not factors, they're elements that the defense must prove evidentiarily for it to show strict and inescapable necessity of closure. I'll jump straight to the first element, that is, closure of the proceeding is necessary to prevent a serious and imminent threat to the administration of justice. And there are a couple of arguments that the defense has presented on that point. The first is that inadmissible evidence may arise in the anticipated hearings. But the case law is abundantly clear that whether or not inadmissible evidence may arise in a hearing is wholly irrelevant to the calculus pursuant to Lewis. As the State versus Lugo said, quote, the need to examine evidence for its admissibility is not one of the prongs set forth in Lewis and is not sufficient to justify closure. That's cited in the materials that we provided to your honor. State versus Houston said, quote, the inadmissibility of evidence has no bearing on whether evidence is or is not public record. And in fact, if anything, as Lewis said, whether or not evidence is admissible, in fact, provides a heightened importance of the right of openness. This is what the Supreme Court said in regard to suppression hearings regarding the admissibility of evidence. Quote, although they may prove to be unfounded, these are of importance to the public as well as to the defendants. The searches and interrogations that such hearings evaluate do not take place in the public. The suppression hearing is the only opportunity that the public has to learn about police and prosecutorial conduct. It is important that a decision of the trial judge on a motion to suppress be made on the basis of evidence and argument offered in open court, so that all who care to see or read about it may evaluate for themselves the propriety of the exclusion. So if anything, hearings on admissibility of evidence mitigates toward openness, not against openness pursuant to Lewis. The second argument that the defense has made is that there has been and likely will be publicity. And certainly there's been evidence presented of that. The media, certainly they're the promulgators of that evidence. So
Slow down the cadence just a little bit for the assistance of Madam Court.
thank you, I appreciate it. Yeah. I want to be respectful of everybody's time. So there indeed has been a lot of pretrial publicity, but that has never been a sufficient justification for closure for several reasons. First, closure based on alleged negative pretrial publicity is essentially impossible in counties of this size. I point you to the case law we cited on that. There are hundreds of thousands of people that living in this county, and the case law is pretty clear on that point. Second, the defendant assumes that the coverage is prejudicial, which that is something that they must prove, and they have not proven that, just that there's been a lot of it. And third, pretrial publicity is not inherently detrimental to a defendant's Sixth Amendment rights. As the Supreme Court of the United States said in Skellig, which a case that the defense presented to you, quote, prominence does not equal or does not produce prejudice necessarily, and juror impartiality, we have reiterated, does not require ignorance. Jurors are not required to be ignorant of the facts of the issues involved. Scarcely any of those best qualified to serve as jurors will not have formed some impression or opinion as to the merits of the case. Every case of public interest is almost as a matter of necessity brought to the attention of all intelligent people in the vicinity, and scarcely anyone who can be found among those best suited for jurors who has not read about it, heard about it, and who does not have some impression or opinion as to the respect of its merits. A presumption of prejudice is an extreme case, unquote. That's the Skilling case. This quote, pretrial publicity, even pervasive adverse publicity, does not inevitably lead to an unfair trial, unquote. So All that's been presented this far, so as far as just evidence of pervasive, but that has never been enough for those reasons. As to the second element of the test, no alternatives other than a change of venue would protect the defendant's rights to a fair trial. And there has been no evidence presented on this point. The Lewis court presents multiple alternative options that could be available. There was some argument made, but again, this is an evidentiary hearing. Argument of counsel is not sufficient. There could be a continuance, according to Lewis, voir dire, peremptory challenges, admonition of the jury, sequestration. All of these alternatives are talked about in Lewis. These were not even discussed, much less evidentiarily examined, and there's no evidence provided for them. So without evidence, this element necessarily cannot be satisfied either. And then third, closure would be effective in protecting the rights of the accused while being broader than necessary, without rather being broader than necessary to accomplish its purpose. Under the case law, it's referred to as the narrow tailoring test. And we really can't meaningfully evaluate this because the wholesale closure of all these proceedings is about as non-narrowly tailored as possible. Rather than like a narrowly tailored suit, this is more like this is like a bolt of cloth sitting on the tailor's desk, entirely not narrowly tailored whatsoever. We can't really even meaningfully engage with this element because there's been no evidence presented on it. So also just to frame this in context and summary and closure too, this is not an unprecedented situation. Unfortunately, our state has seen its fair amount of very highly publicized criminal matters. Some of them are mentioned in our papers. Eileen Wuornos, Ted Bundy, Danny Rowland, Casey Anthony, George Zimmerman, Nicholas Cruz, many of whom in fact did seek closure under the Lewis test and they tried and failed because the strict and inescapable necessity of closure pursuant to Lewis and providing strong evidence to overcome and satisfy all those elements is an extremely difficult standard that is very rarely met. So because there has not been evidence to sufficiently justify closure as to all three of those elements, the media interveners ask you to deny the defense motion.
Thank you, Mr. Minchin. Ms. Smith, any additional rebuttal pursuant to the state's argument or potentially Mr. Minchin's intervening argument?
Yes, Judge. In both parties, they talk about empirical data. However, if you look at the Miami Herald versus State case, the third DCA case, it specifically says that no case, the Lewis case, nor does any Florida case suggest that a trial court must consider expert testimony or empirical data. So while they said that has not been presented, that's not necessary in order for the court to rule that closure of a pretrial hearing is necessary to prevent imminent harm. The media interveners talked about, we're assuming that the coverage is negative. Judge, if you look at the articles that were introduced into evidence, the title of the articles in the court re-reviews, the PowerPoint, the heading and the titles of the articles, the podcast, all of that, it implies or is negative in nature. None of it is saying wrongfully accused or anything of that nature in those titles. The media interveners talked about this being a high standard, and the preponderance standard is one of the lowest standards in a criminal courtroom or in a criminal case. It's just more likely than not, so essentially a 51%. So the defense would argue that by preponderance, defense has shown each of the prongs established. There is no need for empirical data. Some of the other cases they talked about, I believe in those cases, they were seeking complete closure of the media for all aspects of the proceeding. Again, defense is limiting this to specifically the pretrial proceedings in this case, where different evidentiary items could be found. The Miami Herald case, which the media interveners cite to and talk about a lot, the Florida Supreme Court case, the court did close the courtroom and that was upheld. All the cases that defense provided, the U.S. Supreme Court case, the Florida Supreme Court case, and that third DCA case, all are cases in which it was upheld that the closures that the trial court in those cases did was sufficient and was practical in light of the evidence and the cases that are presented. So defense would argue that based off the evidence and testimony that's been presented, that we have established by preponderance each of the factors or each of the prongs needed to satisfy the court that closure is necessary to prevent that serious and imminent threat, that there are no alternatives necessary or available outside of change of venue, and that the closure itself would be effective in protecting the rights of Mr. Stearns without being broader than necessary to accomplish the purpose. So we would ask the court for that.
Thank you, Ms. Smith. All right, the Lewis case requires that the court shall make findings of fact and conclusions of law so that any reviewing court have the benefit of the reasoning in either granting or denying closure. I intend to do that in writing. Ms. Smith, let me ask you, as far as timing of the court's order, are any of these pretrial proceedings currently set for a hearing before the court?
No, Judge, we were going to request hearing time this week, but wanted to give the court that benefit if you wanted to tell us to ask for after a specific date so that we didn't have to go back and reschedule anything.
I anticipate I'll have an order out well in advance of 10 business days. State, anything further?
No, Your Honor, thank you.
Defense?
No, Judge.
Thank you. That will conclude our hearing.
The USC.
It's back over there. Yeah.
I thought I gave it back. Or not?
Thank you.
What do I have? What time?
You have B, C, and D.
Oh,
Yeah.
okay.
Problem solved. Well, this is.